All right, let's start this meeting. Welcome to everyone. Thank you for coming. I'm Susan Falkoff, chair of this committee. Ken Woodland is the vice chair. Vinnie Picciarelli is the secretary, and we have attorney Mark Rich, the town attorney, and Steve Magoon, the director of planning and community development. And so my understanding is what we're here for tonight is to assess whether we feel like AGO's application to open a therapeutic marijuana clinic in Watertown is complete and ready to send to the full council for a vote on whether to give a letter of support or non-support. And since we last met last week, there's been some work between the attorney and Mr. Magoon and the applicant on finalizing a host agreement. So I'm going to turn it over to them.
Okay. Thank you, Madam Chair.
Yeah.
So at the last meeting, the two applications that we had, one obviously had need of significant additional information, so they've asked for a continuance, so we won't be discussing that application tonight. The council had asked Attorney Rich and myself to work with the applicant for 23 Elm Street to work on the host agreement and see if we could revise the language and come up with a host agreement that was acceptable. Quite frankly, Mr. Rich has done most of that negotiation with the applicant, so I'll let him go through the details of that, and certainly happy to answer any of the questions that either you or have with regard to the process and where we go from here.
Thank you.
Thank you. Through you, Madam Chairman. As you recall, when we began this process, NSAJO Holdings had presented the town with a package of information that included a draft host community agreement. My office presented to their attorneys a number of revisions to the agreement intended to reflect a number of the issues that were raised by the town council, ranging from topics such as the process by which any consideration would be given for recreational sales of recreational use marijuana. That was specifically indicated would require approval of the town council and would not be subject to an automatic determination by the operator. Issues of the amount of the community impact donation as it's framed in the agreement, language with respect to certain tax obligations, certain issues involving the general operation of the facility, the limits on their ability to appeal the payment of taxes, and then the basis by which this agreement would remain in effect essentially for the duration of the facility as opposed to for a set number of years, so as to avoid a situation where the facility will have gained a license and then be in a better position not to as openly renegotiate the agreement. And I'm actually very pleased to report that the attorney was very receptive to our comments. He asked for a couple of revisions of his own. One had to do with, we want to make it clear, this agreement was with this particular company. They wanted to be able to, if necessary, bring in a particular management firm if necessary. That would be an affiliate of theirs, and we were agreeable to that. That's actually a fairly common situation where under a corporate structure you may have a different corporate entity taking over the operation, and so that was agreed to. There's a process for that to be done. They've agreed to the very specific donation amounts that were brought forward at the presentation at last week's meeting. They've agreed to a provision that indicates that they would not be marketing certain products, such as products that would be attractive to children would not be sold. Edibles that would be attractive to children would not be sold. They've provided information as to this agreement being binding upon a subsequent location if they move from this location. So they again were very receptive. There really wasn't a lot of pushback. It was more just determining the final wording to make sure that we were all in agreement. But but ultimately we reached an agreement, and the document that you have in front of you reflects the discussion. I think I've distributed a clean version. I know that there was a red line version that may have gotten confusing at some point with the amount of redlining, but at this point, from the legal perspective, we're very comfortable with the agreement that's before you, and I'm certainly available to answer any questions you might have regarding this document.
If I could just add one other additional item that I think is important to note, in the host agreement also is a provision that the applicant has agreed that they would not pursue recreational sales unless they came back to the town, and we agreed in writing that that was an acceptable proposal. So, so despite legislative or other provisions that might allow that in other situations, in this case, they have agreed with the town that they would not pursue that unless the town had agreed to that.
And maybe you could summarize the mitigation offers.
The dollar amounts? As was presented at the last meeting, there is a payment that would come to the town that would amount to either the greater of $200,000 or 6% of the revenues of the facility, and then there's an additional $100,000 that would be set aside available annually to reimburse the town for verifiable expenses, including additional demands from local law enforcement agencies, police details, other emergency services. So that's essentially a fund that the town could draw from for specific purposes, and then the other amount, which would be no less than $200,000 annually for the life of the facility, would be a general distribution to offset any additional impacts on the town. And then on top of that, there's a requirement that they pay taxes as a taxable entity, and that would be set and limited in terms of appeal.
Okay, any questions from the committee? Yes?
So just a quick general overview from what happened at last meeting. So actually, first we met in October. We came up with a list of maybe a dozen pieces of information that any applicant would have to bring forward, and that was what was presented at last week's meeting. And so we can give you any of that information if you need it, but it was very holistic, talking from parking numbers, parking spaces, trips to and from, security protocols, your anti-loitering policies, how the shop would be outlined, how they treat and interact with patients, and it really went very comprehensive. So any of those extra details, just want to assure the folks at home and in the room, those were all discussed at the last meeting and established at our first meeting in October, and can be found in the documents that were presented to the committee and were in presentation form last week. So those are readily available. So just wanted to mention that before we continue going. And part of that was the host agreement, and we discussed some of the pieces that Attorney Rich and Stephen Goon just went over. And those are some suggestions that we had for languages in every single, it sounds like every single piece that we requested were accepted by the applicants tonight.
Yes, and I would perhaps like to review for the people here that at the October meeting, we discussed what the town would need. As Ken said, he came up with a really good list, but I just would like to make some key points that a city cannot ban a registered marijuana dispensary, but can regulate where it goes. We have adopted a zoning amendment that it has to be only in the industrial zones and only with a special permit, and that by the state law, which we did not change, it can't be within 500 feet of places where children commonly congregate, and that they need a letter of support or non-opposition from us. And so we are limited by the state as to what kinds of actions we can take. I have one question about this host agreement, which looks great, but there was, on page 4, it talks about implementing a comprehensive diversion prevention plan to prevent diversion. And seems a little redundant wording, but I'm not sure what diversion means in that sentence. I don't know who's the best person to answer that question.
Any of us could?
I can take a stab at that. So a lot of Diverting is taking the substance and people who work at the facility taking it and either using it for themselves or putting it aside for their own sale. That's a problem in any pharmaceutical. Our company works a lot with Big Pharma, where whether it's at the manufacturing plant or even the pharmacies, that's a concern, and there's strict regulations on that. We have, as we mentioned before, a security program in place, but on top of that will be an audit and review program. So it's great to have cameras, but if no one's looking at those cameras and doing periodic reviews to make sure that people comply with the rules and regulations, then the security is lapsed. And our program intends to have an audit review program where looking at security cameras, doing independent reviews to make sure that no one is diverting substances out of the facility.
So diversion means diversion to street sales?
Diversion to street sales or personal use.
Okay, thank you. Appreciate that clarification.
My name is Dan Linsky, for the record, from Kroll.
And also, Dan Glissman, Principal of Beltai, and I work with my colleague Mike Ross, and we're representing NSAJO Holdings. Just wanted to add on top of Dan Linsky's comments that the diversion plans and security protocols are required under the state law. So that provision is something that we add into the host agreement, just in its initial draft form. We'd just like to remind the towns that this is something that we do in fact prepare, and it's required by the state, will be vetted by the state, and has to meet their standards. So just wanted to add that.
Thank you. Okay, did you have any comments or questions?
No, thank you. I just, one of the key things that was very important to get into this host agreement was the stipulation that the petitioner would not seek to sell recreational marijuana at this facility, and it would remain focused on medical treatments. That, in my mind, that would have been a deal breaker, and I'm not sure we would have gotten this far if the petitioner hadn't agreed to that. So I do want to thank you for doing that. I think all the other elements that we had talked about, the suitability of the site to sort of minimize disruption in the neighborhood, the security measures, which were quite extensive, that was proposed by Mr. Linsky, the sort of the overall commitment to Watertown by the petitioner in terms of what they seek to do in terms of participating in the community as a partner, I think it's quite complete in the application. So I'm actually quite satisfied with. They've done everything we've asked them to do.
Sorry.
Yes.
Just one more thing in terms of process. So when we had that first meeting in October, we said that all those criteria had to come back to this committee, similar to what we do in a lot of the zoning. The committee level will work out the details and come back with different iterations until they're satisfied, and then the entire council addresses everything. So there's no final decision that's made this evening. It gets referred to the full town council for consideration. So that's another opportunity for folks to come out and for more information to be heard that day as well.
So are there any comments from the public this evening? Yes, let's start with Sally, then Peter, and then you, sir. Yes, please.
Thank you, Madam Chair. Sally Blyberg, 125 Coolidge Avenue, in the neighborhood where this is to be cited. My husband, sitting right here, has Parkinson's disease and is approved for medical marijuana use for pain, insomnia, and a host of other ailments that go with the all-encompassing Parkinson's disease. Right now he has to travel to Brookline, to an area that is heavily congested, poor parking. It's difficult, and it would be a real service to people in this part of Massachusetts if there were a dispensary close to home. We would very much appreciate your giving the entire council a strong vote of approval from this committee. We live in the neighborhood. We are not concerned. We've been in other states where there are dispensaries and see how well they're managed, and we see that there is no loitering, there are no druggies hanging around in the neighborhood. So we feel very safe and very comfortable with the plan that's been devised. And thank you for your hard work.
Thank you.
And I also brought with me a group of other people from the neighborhood who concur.
Okay, thank you. Okay, Mr. Santola.
Thank you, Councilor Falcoff. Appreciate your time. I just wanted to read a letter that I sent to the town council. My name is Peter Santola, and currently and for the past 50 years, 25 Thurston Road in Watertown. So I'm more as a resident. I am also the Director of Recreation, but I'm talking about this as basically a resident first. And Honorable Town Council members, I am writing this letter as a resident of over 50 years in Watertown with children aged 21, 13, and 11. I am strongly opposed to any type of proposed marijuana dispensaries located in Watertown, and this includes therapeutic or recreational use. I am sympathetic to the needs of you. I understand that. I'm fully supportive of therapeutic marijuana, but not in Watertown. With all the great work that has been done with the various groups and the resources that we've been utilized over the years, especially over the past several years with educating our residents in regards to drug use, it is objectionable to me that we were ever considering placing marijuana dispensaries in our town. Since there are alternatives to deciding on whether to support or non-opposition, I would hope to inspect that we choose to not support these proposals slated for tonight's meeting, as well as future requests. I think it is important that we send a consistent message to our community, especially our children and those who are most vulnerable. And I appreciate the conversation. And I understand it's a very sensitive topic, and we're only 4.2 miles, and I don't want to branch it out to the Cambridges or Newtons or Walthams that might be more appropriate for the medical marijuana dispensaries. And no disrespect to the corporation, I understand what you're trying to do, but ultimately, and especially I've seen over the years, decisions that have been made in probably good faith, or all of a sudden, in 2 or 3 years, we're going to be caught up with a concern. And yes, it might go in front of the town council, in front of recreational marijuana, but as a dad and as a parent and person who, loves our children and loves our town, I'm just opposed to that. So thank you for your time.
Sir, did you want to speak? Yeah. We're on television.
Oh, good. My name is Francisco Ulloa, and I live in Coolidge Avenue. I have only 2 questions. The corporation, where is this corporation from? And the management company. Is Massachusetts company? What the history of this management?
Is that both your questions?
Yeah.
Okay, so why don't you sit down and we'll have Mr. O'Donovan answer.
I can speak to that a little bit. I'm Aidan O'Donovan for the record with NSA Geo Holdings Natural Selection. So we are a Massachusetts nonprofit, corporate headquarters in Cambridge right now, but we are bringing our experience from Colorado, where I currently live. I'm moving back here. I grew up in Newton. I gave all this information at the presentation last week, and will probably continue to do so in front of the Planning Board and Zoning Board. So it's a little bit of both, to answer your question. We're Massachusetts-based. Our entire team will be back in Massachusetts within a few months. Our security is Massachusetts-based, but we have the best of both worlds in that we've been in Colorado. I've been out there for the last 8 years working in this industry, and I own a dispensary currently there that's been successful, that has done good things in the community where it's sited, and I'm proud of everything we've accomplished there. Does that kind of answer what you were asking? So right now there is no management company. In the community host agreement, we put that together just because at some point when we're going to need to be raising money in addition to the funds that have already been committed. And right now I think that there would have been a risk, and Dan with my lawyer can probably speak to this, but there would have been a risk that if it had to be solely under NSAJO Holdings, that we couldn't add and subtract financiers and members to that board. And Mark could probably speak to this a little bit more. I mean, a commonly owned subsidiary, we're not going to be getting this license and then putting it in the hands of another company. It's going to be us running the dispensary, 110%. That you have my word on, and that is, I think addressed in that it can't be an outside company without the same principles. Right. Correct?
That's correct.
Was that sufficient, I think?
You're satisfied? Okay. Any other comments? Peter?
My name is Peter Blyberg. I'm at 125 Coolidge Ave, and I can't really imagine any kind of problems that would occur beyond having a pharmacy or not even a liquor store. Let me ask you a question. Do you have different strains?
Yes.
And that's another plus, is that they've been experimenting with different strains of marijuana, which would have different effects on different ailments. So that's an advantage. They have experience in growing this stuff and testing it. So it would be convenient for me to walk to a dispensary rather than schlep into Brookline or wherever to get this stuff. And that's all.
Thank you.
So I'm an advocate for it.
Yes.
Hi, good evening. My name is Alicia Sandiuch. I also live on Coolidge Avenue. I have a question and a comment. The question is, does the agreement have any events of default? Under what circumstances, what can the company do in a negative sense that would terminate their right to be able to have this dispensary?
If I may.
Yes.
The agreement does not determine the right of the entity to have this dispensary. That's based upon the licensing that will be obtained through the Department of Public Health on the state level and based upon the issuance of the letter of support or non-opposition. The agreement is a business agreement between the town and the dispensary as to how certain business arrangements are enforced and in place, and this agreement would be in place for the lifetime of the facility. So if the facility was no longer able to operate, if they lose their license, obviously this agreement will become null and void. If the town chooses to terminate the agreement, which is not likely since the town benefits from the agreement, if it's approved, the agreement will continue in full force and effect. The termination of the facility would be based upon licensing at the state level, and obviously they obtain the special permit and the letter of support or non-opposition from the town.
But there must be, maybe it's the licensing authority that would be able to step in if the company does take actions that are negative or against the general agreement, if they start selling edibles, if a school opens, within proximity to the dispensary. I know this is not going to happen. I'm just trying to get you an idea of where I'm coming from.
The state would not enforce this agreement. The host community agreement, again, is a business agreement between the town and the dispensary. With respect to the licensing and the regulation on the state level, again, that's through the Department of Public Health. If they violate requirements of their license, if they are in violation of the regulations, then that would be an instance where the state would step in, could revoke the license. If they lose a license, they can no longer operate, and then again, this agreement becomes null and void. But there are significant measures in place. The regulations for registered marijuana dispensaries are already in place.
Right. All right.
More similar to the way a hospital or medical clinic would be
I understand.
licensed.
And so my comment is that I support the dispensary. It's going to be in our neighborhood. It seems to have been carefully thought out, and in answer to the comments made earlier, the majority of the voters have voted for it. So to me, it makes sense that if that is the correct location that has been decided, I am definitely in support of it. Thank you.
Thank you.
How's everyone doing? Peter Asian, 27 Elton Ave. I'd just like to start out by saying, I'm not opposed to medical marijuana by any means. I know it has its place. I know it helps a lot of people. My problem is I also know many people who have taken advantage of this in this state and in numerous other states. Simple to get a doctor to sign off for basically nothing. And that's what I'm afraid of here. We're 4 square miles, we're right next to Boston. I don't understand why we can't be different. Why can't we say, the one question is, why can't we say no? How come everyone keeps telling me we're not going to be able to keep them out? Why is that? And second, I understand that you said they would have to come back to you in order to, talk about a license. Like, can't there be wording that says, no, you can't sell recreationally ever? That would make, I know it would make myself and make a lot more people in this town, get on board with this. It's fine that they say, they still have to come and negotiate with us, but, does this company also sell recreationally in Colorado? Is that something that they're already doing? Because, they could say that, they don't plan on doing it here, but, what's to say a year, 2 years, 5 years down the road, that's not the case, So.
Well, I wonder if maybe both Aiden and the attorney would like to address that.
Yeah, go ahead. That's all. I'm opposed to it, though.
Thank you.
If I may first, with respect to the ability to just say no, the legislation that's been enacted with respect to medical marijuana prohibits the town from saying no. If anybody's told you that communities are saying no, that's not correct. There's an allowance for a zoning process which the town has undertaken. And what the intent of this agreement is to regulate to the extent that the town can through agreement. With respect to recreational marijuana, the agreement doesn't say they can come back in and apply. What it says is they need to get the approval of the town council. Town council can say no under this agreement, and right now that's not something that's being discussed at all. But the agreement does not anticipate recreational marijuana. But given what has changed statutorily, we have to anticipate that at some point they may come back and ask for that. They're a business. We don't know what's going to happen in the future. But with respect to the approval process, that under this agreement, by signature of both parties, if this agreement is executed, would leave in the hands of this council whether to approve it or not. So again, it's not a situation where the town can prohibit it. The town does have the ability to determine whether to issue the letter of support or non-opposition based upon the determination about whether this is an appropriate location and whether this is an appropriate applicant, and that's ultimately a decision that will be made by the council, a vote of the full council.
Speak a little bit to that as well. Just to clarify, and I think I talked a little bit about this last week as well, we do sell recreational in Colorado. We sell both. I want to make that very clear. I want to be transparent about that. I don't think we're going to be eligible for the rec license, at least not in the first year in Massachusetts, because we don't have a license already. So you're talking about several years from now before we're even eligible for that license. At that point, it becomes a business decision. If things are going smooth, and I'm confident they will, and we decide to go that road, we come back to council and negotiate, and at that point there's a series of public hearings that take place, and they have all the right in the world, based on the community host agreement that we've been working on this week, to say, no, we don't feel that that's right for this community. Whether or not we even come back asking is going to depend on a whole host of factors, but it's going to be at least a few years based on the state licensing system. But as far as Colorado goes, we're able to do that out of one facility to cater to both the recreational and medical markets. So I don't want to, I'm trying to not mislead anybody about that, because I talk mostly about my experience in medical marijuana, but we do sell both in Colorado.
Thank you. Any other comments? Councillor Canellis.
Thank you. For the record, Angie Cunelis, East End Town Councilor. I made quite a few comments last week, and I think everybody knows my position. I certainly empathize with Mr. Bleiberg and his particular need for medical marijuana. I've stated repeatedly and put it in writing, I feel that medical marijuana is between the patient and their physician. We are discussing the siting of the facility. If marijuana were legal, it would be dispensed through pharmacies or hospitals. It's not legal. It's something that has been voted in the state of Massachusetts. I did some research today using my town computer and looking up marijuana, so that's going to be on file what I'm doing. I'm not the most technically savvy person, as I think as everybody knows, but
But you're a quick learner.
Thank you. But I did do some homework. I think that the Colorado facility is in North Glen. Is that correct? Yes. That's a community of 7.49 square miles with a population of 37,000. Another facility that has come before this council, this committee, is in Salem, Massachusetts, a community of 18,000.07 square miles. A growing facility in Amesbury, 13,000.71 square miles. Watertown is 4.17 square miles with a population of 33,000. We're a very densely populated community. I thank all the residents from Coolidge Avenue for coming out, but we also have residents within the 500-foot radius of the proposed facility. It's also somebody's neighborhood. As I indicated last week, we're not second-class citizens in Watertown or in the East End. I take this very seriously. If my colleagues were to go online and look at some of the photographs of facilities, you will see lines of people outside of the facilities. Facility in Salem is in an industrial park. It's an old mill building across the street from a cemetery. It's not a residential area. In the area of North Glen, Colorado, that's not a residential area as well. In the east end of Watertown, we have commercial and residential properties immediately abutting each other. As I indicated last week, does this mean that a child will never live on Clarendon or Berkeley or Elm Street within 500 feet? Will other properties coming up for sale not be where children congregate? Are we changing the character of our neighborhood and altering the rights or denying other property owners the rights of using their property as they so choose because we are talking about siting a facility where children cannot congregate within 500 feet? This is the east end of Watertown. In 2014, the planning board report was given to the town council, and the town council voted on July the 15th, 2014, to allow medical marijuana in the industrial I zones 1, 2, and 3, predominantly located in the east end of Watertown. I was the only sitting councilor who voted against it because of the east end. Medical marijuana and recreational marijuana, the laws are both still moving targets, including medical marijuana. The law that the sitting council voted on, and I state this is on page 2 of the planning board report, nature of the request. On November 6, 2012, Massachusetts voters approved the use of medical marijuana for medicinal purposes, and it goes on. Under the law, there can be no more than 35 registered marijuana dispensaries approved statewide and no more than 5 per county, et cetera, et cetera. That has all changed. It's a moving target. I was not aware that the laws had changed, and I don't know if any of my colleagues were aware. I found out when I received a courtesy call last summer from a proposed applicant, and I inquired how many there were in Middlesex County, and I was told that's no longer an issue. There can be as many. Well, the laws continue to change. What are we doing here? We're entering into a legal agreement for an issue that is still moving. We're subjecting our community and our residential neighborhood to laws that are constantly changing. As I indicated, medical marijuana could be beneficial. I'm not a professional, I'm not a physician, and I empathize with somebody who needs an alternative form of pain relief. I have a 98 years young mom at home And I know what it's like looking at your loved one who's going through some issues with pain. There can be alternatives. I also sent along to the committee and to the entire town council lots of communication that I received via email specific to medical marijuana and their opposition to the siting in the East End. So maybe legal counsel can advise us on what through you, Madam Chair, as to what the town council voted on and the laws that were in effect at that point in time, and how the laws have changed and how the laws will continue to change. It's a moving target. Do we even have a right to be voting on this? That's not what we voted on when we agreed, except for my vote, to cite these facilities in the I zones.
Okay.
The laws were different.
Thank you for the comment, and let's see if Attorney Rich would like to add anything.
Thank you, Madam Chair. The town did enact a zoning ordinance that allowed for the location of these facilities in an industrial district. That zoning law is in effect. Laws do change. Laws in all areas change. The Zoning Act itself was recently amended. Laws are not laws are not of a fixed nature. They are not static. They in all areas they change. And yes, there are changes as this area is evolving. But the zoning ordinance that was passed by the town is effective, and the town right now is considering its ability to negotiate a host community agreement. And under the current status of the law, as a component of the licensing process, is the requirement for the submission of a letter of support or letter of non-opposition. And that's the crux of what will ultimately be before the council. But at this point, you have a valid zoning ordinance in place, and the ability to consider both this host community agreement and the letter of support or non-opposition.
Sorry, I have a question on that. I have a quick, question and statement on that. So when the voters approved the 2012 ballot measure there, it limited up to 35 RMDs in the first couple of years or something, and I think the implication was that that's no longer there because we got so many, but the truth is, and I think we learned this in October, that there were so few in the state. There's only like 4, am I making this up? There's only a few. That's might have been you in October, but there was only a couple. So I just didn't want the implication to be that they're growing everywhere, and that was a part of the changing law. I think that was implied, kind of, but just that there was only a few of them that came out.
Yes, you're the person who did a nice job in
thank you
October
very much.
educating us.
My name is Nicole Snow, and I am an expert in Massachusetts medical marijuana. I am the executive director of the Massachusetts Patient Advocacy Alliance. It's the group and coalition that worked to pass the Humanitarian Care Act of 2012, which is Chapter 369. It's completely different from the statute that we just passed in November, which is the Tax and Regulate law. We've been working to implement this program since 2012, and it has been a very, very slow start. We only have 9 operational facilities in the state, and that's serving 39,000 patients. In comparison to how many CVS we have on the streets, that is, we share 9 facilities with nearly 40,000 people. And those folks from all of the state of Massachusetts have to travel a long time. And I think that these folks were nice about talking about Brookline, but the situation in Brookline is that since the population of patients that have been registered, the time that it takes when you enter the facility to when you get your product has been increasing. And for these severely debilitated people, it takes a lot out of them. And I have been getting reports of people leaving before they even get their medication. So for someone to travel all the way to Brookline just to leave, that is terrible for us to hear. And I don't think that the folks from Brookline New England Treatment Access Center wouldn't mind me saying that they actually do need other facilities to open that will pick up the burden of the patients that are waiting for access. The cards themselves, the patients are vetted, and that's the reason why it's so difficult to get a card. I work with patients on a daily basis. Some patients don't receive their card until 6 months after the doctor recommends that they get their card because of the hoops that they have to jump through. The regulations do get updated, but I can tell you that the law, the Chapter 369, has not been amended since it was passed. But we have been working with the Department of Public Health on easing the obstructive nature of the registration process for folks that do need medical marijuana, because it is so restrictive and it is hard to get through. It's cost prohibitive. So you have to have a few funds to get your card. And then when you do go into the dispensary, you're paying for not just a service and a product that is really difficult to get, but you're paying for that medicine to be properly tested so that it can be delivered to a sick individual so that they don't get sick. I think we've been hearing reports on the news lately in California where not everybody tests their medicine, and someone was hurt by ingesting mold. That's not something that we want to see happen here. So that's why we have a highly restrictive program in Massachusetts. We're going above and beyond public safety and safety for these patients and individuals. The testing processes are so stringent. The numbers are barely passable. I think that in Colorado, the numbers are a little bit more liberal when they're talking about standards for testing. We have a high standard for the quality of the products to be delivered to the patient. So I was just, one more note, I was a co-signer on a question for the Tax and Regulate initiative, but we didn't campaign in support of it in order to pass it, because we care about these patients that have been waiting 4 years. And that is our number one priority. And, we just, we're in support of opening up these facilities for folks that want to get their medicine in their own neighborhood.
You may not be in a position to answer this, but I know you did see the presentation in October. I wonder if you have any comments specific to this application.
I do get really great feelings about somebody coming home to Massachusetts from Colorado, someone who left Massachusetts to start in a new industry, to learn as much as they could, to come back and to be back in their own community. I think it's when, folks come from out of state that we don't really know. And I think having the benefit of a community member, someone who is going to maintain contact with you, is another standard that, we all agree with.
Thank you.
You're welcome. Have a good night.
Yes.
Can I just make a question? Thank you. I just wanted to, I know Council Canellos raised the question, but Chapter 369 of the Acts of 2012, which enabled medical marijuana, has not been amended. Section 9, paragraph C says, in the first year after the effective date, the Department of Public Health shall issue registrations for up to 35 nonprofit medical marijuana treatment centers, provided that at least one treatment center shall be located in each county, with not more than 5 located in any one county. In the event the department determines in a future year that the number of treatment centers is insufficient to meet patient needs, the department shall have the power to increase the number of registered treatment centers. So the law hasn't changed. We've heard that there's only 9 in the entire state, so we haven't even met the 35, but the law gives that Department of Public Health the ability to change the number of...
By regulation.
By regulation.
Thank you. Okay. Okay, Mr. Santola.
Sorry.
Why are you sorry?
I'm speaking twice today, so thank you very much. It's one of the things I always like to get educated about these, and I would have said I'm very sensitive to the fact of pain and suffering. As I get educated, I guess I'll ask the gentleman from Colorado. I mean, I grew up in Watertown. I'm a Wat rat. I love Watertown. There's only 9 in the state. Why us? Why now? That's a big thing. And the other thing I don't understand, if it's, and to Council Canellis' point, if there is a truly medical need and we have a doctor, why doesn't, and I'm not going to pick on CVS, but why don't we give out the drugs like we give out every other drug to a pharmacist? Why do we need a dispensary? And again, I just like to get educated on that. All right, thank you.
We actually had to go about changing the law through the 10th Amendment process because the federal process of changing those laws and regulations were too slow. And because of the nature of human suffering, I think that the residents of California were the ones that really pushed it over the edge during the AIDS crisis, that they were going to do whatever it took to ease their pain and suffering. So from that beginning, we're here to this end, and we do advocate for truly safe access through security, but to get around the FDA and, the lack of studies and everything else, we had to pass a state ballot initiative. And then that means it's an alternative medicine, sort of like how folks get access to massage therapy and acupuncture. I think that because of our advocacy and the work that we do in Washington, D.C., we'll actually be able to see some of those restrictions change, and probably starting with the banking and the physicians and everything else. And actually our group, with the regulations as they are now and with some of the proposed changes, we're looking to actually move some of this medicine into hospitals and nursing homes and hospice centers and other low mobility homes. So it'll become more traditional, just it doesn't happen overnight. You're welcome.
If I could just, a quick comment on I guess, the inverse of your comment. I think it would be great if CVS, if someone got a prescription for some sort of pill or something, they took the time, like a lot of the facilities that have presented here, when someone walks in, to talk to them about what the product is, what's the proper treatment for it, how much you're supposed to take, and go through an entire series of regimen with them, and said, this is the healthy way, this is best for you, and went through that process with them. So I guess I think you're right, but it sounds like what we have in front of us is going to be safer than going into a CVS, because they're taking those proper channels to talk to the patients about that process. So I guess my argument is very similar. We don't have those requirements. We probably should for these other drugs that are leading to substantial increases and potentially have addictive qualities. Just wanted to mention that.
And to answer your question about why Watertown, I actually grew up right in Newton, up pretty much on the border in Nonanthem, off 2 houses in from Watertown Street. So I'm from down the street as well. I said last week I got my license at the RMV there. I used to Christmas shopping at KB Toys. Is KB Toys still around? I don't know.
No, long gone.
But the zoning and real estate availability was a huge factor, as well as proximity for patients. I mean, within a 5-mile radius of our site, I think it's about 460,000 residents, and there's going to be a lot of those who are medical marijuana patients. Additionally, the space that we chose, I think, is, it's off. It's not right on the front of Elm Street. It's behind the building there. Again, last week we had a PowerPoint up, but I didn't have it this week. But it's a building behind a building. So when that became available, which is another factor, is not having to displace anybody. I think a lot of times communities, especially in Massachusetts, have very strict zoning for medical marijuana dispensaries, and in order for a company to get licensed, they have to displace another business, which I had to do one time in Colorado, and it's not easy, and it's not ideal. So this it was empty, it was empty building that a tenant had recently vacated. So it's bringing a new business to the area without displacing any other business. It's bringing jobs to the area, money, community host agreement. Does that kind of answer? Great.
Okay.
Just quick, I just wanted to say,
We'll let Peter have the final
yeah,
word.
just real quick. I mean that, like I had stated before, I'm not against medical marijuana. I just, and if this is here, this is here. The one thing I would ask the council is to, have it in as strict as terms as possible to try to make sure that this is never recreation. I mean, he's selling it out in Colorado. He's a businessman, all right? And obviously there's going to be money to be made there. So whether it takes 2 years or whatever, he said could be a few years down the road, it's coming. He will ask you. So to have it in as strict terms as possible that, you're not looking good, you know what I mean? Because that's what's going to come, no doubt about it. And, it's nothing against him. Like I said, he's a businessman, you know what I mean? I understand, but that's the concern of most of the people in my circle and a lot of people that I've talked to. So I'd just like to have the council take that under consideration.
So I have a question for you. So if, let's say you had a guarantee, and I'm not saying you'd get one, but say there was a guarantee this will never be a recreational marijuana clinic, even if marijuana is legal and you can get it at CVS, would you feel good about this facility?
I mean, like I said, that's my main point is the future. I can't imagine a medical marijuana facility. I mean, they're saying there's only 9 in the state. I mean, that's a lot of patients that they're, but I still can't imagine that there's going to be a line down the street. So I'm not as concerned about that, but I am concerned about the future. I am concerned about what it's going to say to our kids when and if this company ever asked, can I do it? Having a storefront and having my nephew saying, oh, what's that for? You know what I mean? It just gives people the green light in their head that this is okay. Even though the voters of the state, I think blew it on that vote, but that's for another day. All right.
Thanks, Peter. Okay, so I'm going to close this hearing and see if anybody would like to make a motion. I have the feeling Vinnie would.
Madam Chair, I'll make a motion to refer the application for a medical marijuana treatment center at 23 Elm Street by NSAJO Holdings, Inc., as submitted to the Town Council on February 24th, along with the host...
January 24th. It says January.
January 24th. The application was submitted to us.
We haven't had February 24th.
So, did I say February?
You did.
January 24th, along with the host community agreement as presented tonight, February 7th, back to the Town Council for a vote for a letter of support or non-opposition.
Second.
All in favor?
Aye.
Aye. Okay, and did you have an additional motion?
I'll make a motion to, there was 2 items on the agenda tonight. I will make the motion that the matter of the Alternative Therapies Group application be continued to a future meeting.
Second.
All in favor?
Aye.
Aye. Okay, so future opportunities to talk about this. There will be a hearing at the council, and President Sedaris, do you have anything to say about that?
Just quickly, I've had some conversations with the Director of Health, and potentially the Board of Health would like to have a discussion about this also, so I'm still formulating how we're going to move forward with this. I will say that we're going to give the public a minimum of 1 or probably 2 opportunities to weigh in. So I do think that we have to make sure that everybody is aware of what we're doing and how we're doing it, and make sure that the Board of Health and the Director of Health, who is tasked with some of these issues, is on board with this, and we have a discussion.
So, Peter, I have a question for you. Just a thought. I understand there was a lot of discussion about this at the Drug task force meeting yesterday, and I wonder if it might be helpful for you to invite the applicant to speak to that group at a future meeting?
That's a possibility. I was not there, I was traveling.
Oh, okay.
So, but I did email with a few people, and they were voicing their concerns, similar concerns to me. You know, I still come back to why us, you know what I mean? I understand by law we can't say no, but I will discuss it with everyone there, and I'll see if we do extend an invitation to have them discuss it with us
I would
personally.
expect that they would be glad to do that. Okay.
Also, I just wanted to comment with respect to timing and additional public comment periods. As you all well know, this application will still need to go through the planning board and zoning board process for a special permit, which is a publicly noticed and public testimony hearings. So our client has been at this since June. So we've had a number of appearances before this board and the council, and we respectfully request that the next hearing be at the next available hearing for either February 14th or February 28th. Like I said, we've been at this since June, and there will be additional public comment periods through the zoning and permitting.
President Sedaris is your guy.
But we also, when we talked about last week, we'd like to, I mean, not that there's anything supposed to take place, but we're planning on hosting community meetings. Community meetings as well, 1 to 2 in the next 30 or 60 days.
Okay.
Just so that in a more informal setting where people don't have to necessarily come up to a mic and kind of shake
Right.
hands and ask questions so
So
kind of get a feel for it.
all the scheduling that needs to go on, you might want to be in touch with the council president?
Yeah, sounds good.
My suggestion is if you're planning on hosting a community meeting, which is a good idea, you do that before we have any other meetings in front of the council, which might make it go quicker in the council.
Okay.
Thank you.
Okay, all right. If anybody didn't sign in the attendance sheet, please do. And I think we could have a motion to adjourn.
Second.
All in favor? Aye. Thank you.